Hello and welcome everybody to today's webinar on buying and selling home health and hospice agencies. We are joined today by our panelists Jennifer Papagenatu and Heidi Kochel. And without further ado, here they are.
Hi everybody, this is Jennifer Papagenatu. My colleague Heidi is also on the phone with us. Quickly, I'm a partner with Lyles Parker. I've been an attorney since 1998. I do primarily M&A work, regulatory and compliance consulting, and a ton of enrollment related work, both revocations, initial enrollment, solving problems for people, doing analysis for people under the increasingly more complex provider enrollment regulations for Medicare, but I also do licensure work with the state, so primarily in Texas. Heidi, you want to do a quick intro?
Yeah, hello all. Welcome to today's webinar. My name is Heidi Kocher. I'm also a partner at Lyles Parker, and I've been licensed for well over, I guess it's 25 years now. My practice is, as Jennifer's, strictly in healthcare. I tend to focus a bit more on some of the regulatory aspects, but I also do quite a bit of transactional work and work on audits and defending providers against government inquiries and so on.
Great, thanks Heidi. Let's go to the next slide, Kip. Great. So today we're going to try to cover roughly these topics. We'll share our war stories as we go, but we're going to briefly touch on what the current sort of merger and acquisition trends look like. We're going to cover sort of the basics of a transaction, how it works. We'll discuss some applicable health laws that we worry about when we're structuring transactions, and that can affect everything from how you structure ownership of businesses to how you structure the financial terms of a transaction. We'll look a little more deeply at the steps in a transaction and the kinds of documents that are created. We'll talk about post-closing issues and then a few sort of like special considerations for home health and hospice. Let's go to the next slide. I encourage you guys, if you have questions, type them in the chat box and we will either try to address those as they come up if I see them, or we'll have try to leave some time at the end to take questions. If there are questions you don't get answered, feel free at the very end, you'll get contact information for Heidi and for me to reach out to one of us. It's probably easiest to get us by email. You're welcome to call, and we will be happy to answer any follow-up questions. So, current trends. I went back, I've done this presentation many times, and I did it about 7 or 8 months ago for TAC, and even in that time frame, we see changes in the industry that are driving merger and acquisition activity. Still, even in, April of 2020, we're still talking about the pandemic, and we're still dealing with various pandemic related programs and how they affect mergers and acquisitions. Any provider that had PPP loans received provider relief funds, and that's virtually anybody that was Medicare enrolled at the time they were released, or took out an SBA disaster loan, or has any other kind of financing related to COVID. Those are still big issues in mergers and acquisitions, although we're deeply into it at this point, almost 2 years down the road, and we have ways of handling these things. We have a lot more information now about what the expectations are from the lenders, from the Small Business Administration, from HRSA. Reporting of those HRSA provider relief funds is ongoing. So a lot of these pandemic related issues, if you're looking at selling or you're looking at buying, they still need to be addressed in the context of a transaction and dealt with, because they can throw some roadblocks up. But the good news is 2 years into it, we know how to handle them. So there are a lot less unknowns. If you'd asked me 18 months ago, what do I do if we're selling a business and they have a PPP loan? My answer would have been, that's a really good question. I hope the SBA tells us. We know the answers to those questions now. RAP suppression still a thing, but nobody's on RAP anymore, so actually I should probably take that off of the slide. But the one thing we are seeing a tremendous upswing in is auditing. And there was a lull there for the first year of COVID, or for maybe the first few months. And we have definitely seen the integrity contractors are very active and are resuming business as normal. So we're still worrying about pending audits, additional documentation requests, and everything that goes along with that. We're also seeing more suspensions. This is a tool that integrity contractors sort of outside of Texas were really actively using. There was one particular one back in the Northeast that used it a lot. They'd suspend and audit at the same time. And the bar to suspend a provider is frankly very low, and that's a little disturbing all on its own. But Health Integrity, now Clarent, has been doing this more lately. They'll maybe pull a probe sample from somebody. You know, you get a request for a small sample of records. They'll take those, and then a few months later, or maybe not even a few months later, you get a notice that the agency has been suspended. And that is almost immediately followed by a much larger request for records. That is becoming a more common occurrence with Clarent audits. Let's go to the next slide. I would say the one other really big current trend I'm seeing is that there is a ton of money out there in private equity that is being thrown at building networks of agencies. And there are big companies that are backed by private equity that are out there buying up smaller businesses. And the multiples are still very good. I will say this: you need to have a pretty clean business if you're going to get bought by private equity. They are very rigorous in their due diligence and their expectations for the level of documentation you're going to be expected to provide in due diligence, and also the representations and warranties you're going to make in the transaction, and the kind of indemnification you're going to have to provide. They're pretty expensive. So the money's out there. It's still very active. But those, and I've done a ton of those deals over the last couple of years. I did a quick rundown, and I was telling my colleagues here before we got on the phone that I've done 15 deals in 15 months. Almost, not every single one, but more than 10 or 12 of those are all private equity backed deals where I was representing a seller. And they have just been crazy busy out there buying up businesses. COVID and the pandemic have certainly affected the economics of those deals to a certain extent, but I would say for the most part, sellers are still getting really good multiples, even with, if you had an off year in 2020, the beginning of the pandemic, that hasn't really grossly affected the value of agencies, let me put it that way. And then it depends, it's agency by agency, and everybody's financials look different. But let's talk a little about transaction basics. Couple things.
Jennifer,
yes, Heidi.
Can I just say one last thing about the private equity? One of the things that I have noticed as well is that not only do you have to be a super clean agency, but they also have certain minimums. I mean, these are people that have a lot of money, but my experience is that they're not necessarily going to pick up an agency that has, 10 or 15 patients. They're going to want to look for a certain level of census and a certain level of income and revenue before they do that. So that's another thing to bear in mind.
I would agree with that. I have done a couple of deals with very small agencies that had very low census, but I would say those tend to be what I call distress deals, where the seller is having to get out of the business for some reason, whatever that might be. Might be a personal reason, might be a business-related reason, might be a debt reason. The reasons are all over the map. But I would agree with Heidi that most private equity companies are looking to build market share, and to do that, they need you to have a presence in the geographic area that you serve.
And those distress deals are complementary to their existing base, looking to fill in, maybe a particularly small geographic area or a particular kind of patient population.
Yeah, very much. I very much agree with that. I've done a couple where a company that already has a location in sort of a large, a metro geographic area will come in and buy another provider entity that is distressed and may or may not have a large census because they simply want a larger territory and they want the relationships that have been built between that agency that's looking to sell. So anyway, transaction basics, these are just really high level things. We're going to get into the specifics on a little later on, but transactions take time. And I can't tell you how many times I get a call from somebody who is involved in a sale, and whether they're a buyer or a seller, they want to get the deal done in 30 days. And my first interaction is generally, let's talk about what's required to actually close a transaction. And there are lots of things that extend the timeline longer than anybody really wants. I will say when I'm working with larger buyers, they understand that transactions take time. Smaller deals can certainly be done more quickly. There's the due diligence tends to take less time. And if private equity is not involved, then the level of scrutiny can be a little lighter. But generally speaking, I don't ever tell clients that I think a deal can get done from beginning to end, and that's like sort of from the letter of intent stage to closing. You should expect 60 to 90 days. That's what you should mentally prepare yourself for. It can be longer, it can be shorter. It really depends on the circumstances, but they take time. So it's something to keep in mind. If there are reasons why it needs to happen faster, those need to be brought up at the beginning so that you can strategize the best way to manage them. Again, the things driving sales are everything from it's just too much money to turn down to I don't want to continue to run a healthcare company in the current regulatory environment, which I completely understand. The level of expertise and sophistication that operators have to bring to bear these days is such that it takes a certain amount of infrastructure, and it takes a certain amount of sophistication and resources to really perform and be successful from a financial perspective and a clinical perspective. So the larger companies have those tools available to them, and oftentimes it makes sense to go that route, to affiliate with a larger company or sell out to a larger company. Third bullet, do not navigate a deal on your own. You will regret it. And I say that selfishly as a person who does these deals. The last thing you want is to sell your home health agency and sign a purchase agreement that you've never had an attorney review. You have no idea what you might be agreeing to. I mean, we can all read the document, but you need to understand that oftentimes there are things in there that that may not be in your favor, especially as a seller. And it is, I think, critically important that you get legal advice and that you get it early on. I had an interaction with somebody recently who was wise enough to come and reach out before they ever even hire a broker to help them sell, which I think is great. It is so helpful to have some input from an attorney who works in the area and has done sales and is familiar with what sort of industry standard terms are, can help you think through the economics of the deal and what might affect how it plays out for both buyer and seller. The deals that I've had that don't work out can often be a result of not understanding the economics of whatever, or the financial terms, or or making the assumption that just because a letter of intent says it's non-binding, it doesn't mean that the expectations that are set by that letter of intent aren't critical to the parties' relationship going forward. A health lawyer who works in this area, whether that's me or Heidi or anybody else, can help you think through, what are the really critical points we need to figure out very early on, and what are the things we can maybe leave more flexibility to determine as we go through due diligence and draft transactional documents. I also highly, highly encourage, especially sellers, to have a good relationship with an accountant. An evaluation expert would be great, or a really good broker who can help you understand what your business is worth, and from an accounting perspective can help you make sure your books are in really good shape. And same if I'm representing a buyer, it's important to have good valuation up front to understand what it is you're buying, and someone who has the expertise to review the financials of that target and give you an honest opinion of it. All right, let's go to the next slide. Do your homework and don't be afraid to walk away. As a buyer, this is so important. You've got to do due diligence. You cannot take people's word for it. And I know that sounds very negative, but everything from verifying that the financials are accurate, that the clinicals are good, that the regulatory history is clean. There are a lot of things we can do to evaluate those factors, even in a small deal. Private equity firms and large companies buying up smaller businesses really spend a lot of time on due diligence. They may have multiple consultants that come in and look at various aspects of your business before they put pen to paper and even draft a transactional document. Second bullet, many deals reach the letter of intent stage and never close because of various reasons. It could be facts that are learned during due diligence, or it could be something just changes between buyer and seller that affects the dynamics of the deal. I again, on my list of like 15 deals in 15 months, I think I've had 3 that haven't proceeded, and 2 for very specific regulatory liability reasons. Actually, one was a litigation issue, one was a liability issue, and the other because the seller just changed their mind and decided that they weren't ready to sell. So Heidi, I don't know if you have anything to add on that, but I was just going to say, I just had a transaction, a deal terminate this last Monday because of the financials had been done on a pro forma basis, and when they looked at the actuals were, shall we say, a little different from the pro formas. Right. And the deal just didn't make financial sense for the purchaser anymore. Yeah, I touched briefly on the ones where I've been working on. One was just the seller change of heart. One was the seller who I was representing actually was sued in the middle of due diligence, which kind of scared the buyer off. And the other was a liability. As they were evaluating liabilities and looking at risk, the buyer just simply didn't feel comfortable moving forward, and that that happens. That's why you do due diligence. So, and in some situations, those risks they change over time, and buyers sometimes come back around in a deal that maybe gets put on pause, and facts change, or an audit's completed and turns out better than you expected, or litigation gets settled, and those deals come back to life. It happens. So, regardless, just because you get to the letter of intent stage, doesn't guarantee you're going to get to closing. But as a transactional lawyer, my job, Heidi's job, is to get through the process and get you to close on the terms that you prefer. So I tell people when I represent a seller, that's my job. My job is to get your deal closed on terms that you accept and that you're comfortable with. And there's a lot that goes into getting there. So it isn't as straightforward as you might imagine sometimes. Most deals, every deal has specific facts. Every seller and every buyer has a unique scenario, but they all generally follow and have common documents and common processes. I agree, the bullet here says 70 to 80% of documents are standardized and transferable from industry to industry. So the asset purchase agreement or the equity purchase agreement that you use to buy a home health or hospice agency, about 2/3 or even 3/4 of it looks very similar to what you would use to buy a restaurant or, any other business. But 20 to 30% roughly is going to be very specific to home health and hospice. There are regulatory issues that are very unique, and there are certain aspects of the business and how they work, both from an internal operations perspective and also from a revenue perspective, and they have specific regulatory risks that don't exist in other industries. So all of those get addressed in some form or fashion in the transactional document. So just because an attorney has worked on a deal to buy a restaurant or to buy some other non-healthcare business does not mean they are going to necessarily understand and have specialized knowledge or expertise in how to buy and sell home health and hospice agencies. So I encourage you to find somebody who has experience in this specific field, and hire them rather than a generalist who does just business transactions in general. Let's go to the next slide. All right. So there are some sort of standard steps that we generally see in deals, and we almost always start out, at least in 90% of the deals I've done recently, with a letter of intent, often called an LOI. It isn't required. You don't have to have a letter of intent, but they are extraordinarily common. And the reason is the transactional environment has been so active that buyers especially want to lock up a seller for some period of time while they get through due diligence and get to a purchase agreement. A letter of intent will often include a no shop clause, exclusivity, confidentiality, and those terms are enforceable, and they will generally keep the seller from talking to anybody else about the business that they're trying to sell while they're negotiating with the buyer, and while that due diligence gets completed and while they're drafting the purchase document. That really, in my most recent experience, is why we are almost always seeing letters of intent. They don't want somebody else swooping in and trying to buy the business while they're negotiating with you. And it is the first and best opportunity to set expectations between the parties. You're going to be talking about purchase price. That's going to be discussed in the letter of intent. You're going to talk about the most important financial terms and some of the, what I would consider hot topic issues in any transaction are going to get addressed in that letter of intent. After you get through that stage, and keeping in mind that most of the letter of intent is not what we call, they're not enforceable promises, but they do set expectations. The enforceable promises are going to be, a very small portion of that overall letter of intent. Next step is due diligence. Third step, purchase agreement, where you're going to define purchase terms and price, including any holdbacks, escrows, and earnouts. You're going to specify representations and warranties from both parties. You're going to document what the indemnification provisions are going to look like, any exceptions or limitations of those, and define what other ancillary closing documents are going to have to be provided in order to actually bring the deal to fruition. And then eventually you'll get to closing. And that is always a stressful but exciting time for buyers and sellers. So let's go to the next slide. I can't stress enough, again, before you draft and sign a letter of intent, or especially a purchase agreement, hire an attorney to help you look over that and make sure, especially if you're a seller, and again, even if you're a buyer, that that this has been done appropriately, that it represents a good balance between the parties and reflects the terms everybody agreed to. Keep in mind that federal and sometimes state law can impact the terms and timing of a healthcare transaction. Your attorney can help you outline limitations in the purchase price, financing, those periods, and other key terms so that you understand the process and ultimately how the purchase, the money part of it's going to work for you. And that includes talking and thinking through taxes and all sorts of other issues that come up. I'll give you an example. If a buyer is going to pay a seller over time, we worry about healthcare fraud and abuse laws, specifically the anti-kickback statute, because sometimes, depending on the structure of the deal and whether that seller is going to remain active in the healthcare industry, that can affect how we structure financing terms. So consult with an attorney to help understand both the process, the regulatory issues, and to be sure that the documents that are being generated reflect what everybody's agreed to. Let's go to the next slide. So I mentioned health laws that can affect the overall structure of a transaction. There are really two major ones we think about, one of which is less of a concern, and that's the Stark Law. I'm sure everybody's heard of the Stark Law. It's a federal civil law that prohibits a physician from referring patients for designated health services to an entity with which the physician or his immediate family has a financial relationship, unless an exception applies. The good news for all you hospice owners is that hospice is not a designated health service and is not subject to the Stark Law. Home health is a designated health service, and it is subject to the Stark Law. And the way that law is structured and the regulations implementing it have made it virtually impossible for a physician to be a significant owner of a home health agency if that physician's ever going to refer a patient to the agency. So I don't often, and I'm sure Heidi would second this, I don't often see physician owners in home health, and as a result, we don't worry a lot about the Stark Law and transactions. If I have a home health agency that does have physician ownership, then we do think about this and we do worry about this, but it's fairly uncommon. The exceptions that exist to allow physician ownership in home health are so small that it's not very common. Heidi?
Yeah, I had one transaction where a physician did want to buy a home health agency for the express purpose of referring patients to there. And the physician wasn't familiar with the Stark Law, and so we had to explain the situation. And yeah, that transaction ended up not moving forward.
But that's a great example of why it's important to have a healthcare attorney involved, because a regular business attorney who never worked in healthcare probably wouldn't know that. And
exactly,
may or may not pick up on that. And the minute that physician becomes an owner of that home health agency and makes a referral, you have a problem. So it is something to be aware of. But again, I don't often see it become an issue in transactions. The Stark Law is a strict liability civil statute. If you don't fit within an exception, then every claim filed by the home health agency is at risk of being an overpayment and being subject to potential fines and penalties. So again, it's important that you rule it out early on, that it's often not a huge issue. Let's go to the next slide. Okay, there is an exception for what we call isolated transactions if we do have physician involvement in ownership, whether that's on the seller or the buyer side. I've outlined the terms here. I don't want to spend a lot of time on it because, frankly, we don't see it very often, but let's go to the next slide. We do worry about the anti-kickback statute. The anti-kickback statute is a federal criminal law, and it prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. And everybody is probably sitting here going, well, how does this apply to a transaction? I'm not paying a doctor to refer patients to us. I'm not, there's no payment for referrals here. Well, the lovely folks at the Office of Inspector General, who oversee the anti-kickback statute and wrote all the implementing regulations, are very confident that transactions among parties who may refer to each other are subject to the anti-kickback statute. I'll tell you the kind of deal where I generally see this become an issue is when a physician is selling their practice and is going to stick around. If that physician is going to remain in the community or become an employee or something of that nature, then we worry about the anti-kickback statute and structuring the transaction to fit within an exception, or as close as we can get to an exception to the anti-kickback statute. And if we go to the next page, we'll talk about the sale of practice safe harbor. And again, the anti-kickback statute, because it's a criminal law, it's an intent-based statute, and it requires, proof of the party's intent, and there's a whole body of law that's developed about how you apply the anti-kickback statute. But the good news is that we've been given regulatory safe harbors that define conduct the Office of Inspector General thinks are not a violation of the anti-kickback statute. Unfortunately, we don't have a specific anti-kickback statute safe harbor that applies to transactions involving home health and hospice agencies. We only have one that applies to the sale of physician practices. But we can analogize, we can take the requirements of that sale of practice safe harbor and kind of translate them into the home health and hospice environment, and feel reasonably comfortable that if we've followed the terms of that regulatory safe harbor in our home health and hospice deal, then we shouldn't have huge risk of a potential anti-kickback statute issue. So the sale of practice safe harbor, again, it applies to transactions among practitioners, and when we say that, we mean among generally physicians and between practitioners and hospitals, but we can use it as a go-by for home health and hospice deals. What it effectively does is the safe harbor puts time limits on how long the parties can take to complete a transaction and on the referrals post-sale between the buyer and the seller. I don't want to go into the nitty-gritty of it because frankly it's pretty complicated, but it exists, and it is something that we use depending on the facts of any certain situation. I'll tell you where it becomes an issue. It's when you have a home health or hospice agency and it's selling out to a buyer, and the owners of that agency are going to somehow continue to actively work in the same geographic territory as the agency they just sold and serve as a referral source for it. I'll say honestly, that isn't very common in my experience over the last many years. It's a lot more common in physician deals than it is in home health and hospice. Almost every home health and hospice deal I've done where a seller sells out to a larger company or to anybody, the buyer wants a non-compete from the seller. And that non-compete can be, you can't have any other home health or hospice business. And sometimes it limits other activities in healthcare as well. But realistically, I would say in most of the deals I've worked, and Heidi, you tell me what your experience has been, that my sellers that I represent, they're retiring. They're getting out of healthcare. They aren't going to be continuing to serve as a referral source. And for that reason, we often don't have anti-kickback statute concerns. Let's go to the next slide.
Yeah, I would agree with you that in the home health and hospice space, most of the people are selling. They're either retiring or they're willing to become, particularly where you have private equity coming in, they're willing to become employees of the purchaser.
Right. So what do we do if a deal doesn't fit a safe harbor? Well, that's where Heidi and I earn our money, and we help analyze the transaction and document how we've mitigated potential risks if we are concerned about anti-kickback statute liability. And there are steps that can be taken, including making sure the purchase price represents fair market value and valuations by professional valuators that help justify the money that's changing hands so that it doesn't appear on paper and in reality that what's happening is a buyer is really overpaying a seller to ensure an ongoing stream of referrals. That's really ultimately what we're concerned about. We can pay you for the business as it exists today, but we can't pay you for all the business we think we're going to get from you later. All right, let's go to the next slide. Heidi, are you ready to pick up from here?
Yes, give me just a moment to flip over here. And I just would want to say to Jennifer, on the point of not overpaying, that's another reason, again, why you want to have evaluation up front. It just helps address some of those concerns. So, okay, so as Jennifer had said, a letter of intent is optional, but it is very, very common. I actually like to do one because what it does is it helps as a negotiation tool, and it lays out your key terms of your transaction. It gives you the framework around which to build your purchase agreement. As the slide notes, it's generally non-binding, but you do want to have certain provisions in it that stay around, that survive closure and so on, and or termination. I'm going to cough here. Sorry, the wind is really kicking up a lot of pollen today. So some of the things that you want to make sure of is if you terminate the deal without going to closing, you have non-disclosure provisions and sometimes exclusivity provisions up to a certain point, again, as you try to salvage a deal. The letter of intent, as the slide says, can and really does set the tone for the negotiations. It is your first step. It is where the buyer and the seller demonstrate good faith with each other. And if you have trouble with crafting an LOI, then you're going to have trouble with the purchase agreement and the rest of the documents. That's my opinion. And as Jennifer said, again, you want to seek legal advice because there are provisions in here that will survive termination or closure, and you want to make sure you understand what all of those are. Next slide. So after you've signed the letter of intent, your next step is going to be due diligence. And the phrase that applies here is caveat emptor, buyer beware. Both parties will want to do some due diligence, but most of the due diligence usually comes from the buyer. I would say it's probably, I don't know, 85, 15, maybe even 90% of the due diligence is conducted by the buyer. And again, they want to make sure that what they're purchasing is what they think they're purchasing. And again, they're going to look at, audits, they're going to look at regulatory documentation, they're going to look at employee roles, they're going to look at a whole bunch of things to make sure that the representations that have been made in sort of the pre-LOI stage, are in fact true, and that there is the proper payment being exchanged for the value of that agency. So again, we're going to look at financial statements, tax returns, business operations. There may be site visits to office locations. They're going to validate licenses, certifications, all kinds of things they're going to look at. And the list of due diligence documents can be pretty lengthy. And this is usually one of the steps that takes the longest in a purchase of a home health agency. Next slide, please. We do have some special concerns always in healthcare. One of the things we highly recommend is do a mini claims audit. If you intend to purchase the provider numbers by doing an equity purchase, you as the purchaser get all of the seller's Medicare and Medicaid successor liability. So if they overbilled or have some other issues, improper documentation, shoddy documentation, that's going to come on to the buyer's responsibility. So you always want to do a mini claim audit. And by mini claim audit, we're not talking 1,000 records. I can usually figure out pretty quickly what's going on with 10 claims. 10 is probably a little small. You'll probably want to look at 20 claims. But again, you want to get a good sense of their documentation and billing practices. Do engage an expert if necessary for this. And again, what you're going to look for is you're going to look for weaknesses in the medical records or other documents, because you want to have somebody looking at these who has the hat of a government auditor in particular, or an insurance company auditor, who's going to look for the flaws in the documentation. Any flaws in the documentation will either greatly reduce the purchase price, may lead the purchaser to put a fair amount of money in a post-closing escrow to make sure that they have money in case some kind of post-closing audit occurs, or it may even kill the deal. I've had a couple of transactions where the audit has actually killed the deal. All right, next step. Next slide, please. Do not skimp on due diligence. That's I guess my takeaway from that slide. Purchase agreement. This is going to be the document that defines your transaction. It is a binding document on all parties, and it is going to set out in detail the price, how you allocate risk, and other material provisions. For example, you're going to talk about, you know, what happens in the case of an audit. Jennifer mentioned the PPP loans and the HRSA loans. You know, it's going to set out how those get paid off if they haven't yet been paid off, and so on. This purchase agreement is the basis for all of the legal rights regarding closing, payments, liability after transaction has occurred. So it has to be negotiated and reviewed very carefully. And I've actually had a client who sold their home health agency. They had undergone an audit from a payer about 2.5 years prior, but then as the pandemic came into being, everything sort of ceased and they never heard anything more. So they had assumed that they had passed their audit. They went through closing, and 6 weeks after they closed, the payer came back and said, "You owe us, you know, a couple $100,000 from this audit from 2.5 years ago." And that led to just a whole lot of issues with the sellers. How were they going to indemnify the purchasers? Who was going to pay for what? And so on. So you do want to make sure you negotiate the purchase agreement very carefully. And again, if it ends up in litigation, this document is going to be the document that a court looks to say, this is what the transaction was and was intended to be. It's going to be the full and final intentions of the purchaser and the seller regarding the home health agency. So as healthcare attorneys, Jennifer and I spend a lot of time on the purchase agreement once we get to the drafting of that. Next slide, please. We have 3 basic kinds of transactions. One is an asset sale, and that is where the buyer is acquiring certain identified assets, properties, and liabilities, but there is no seller's equity. What you have is you have a new owner and a new tax ID number after the closing. And you usually have a new Medicare IDs as well.
Sometimes, but I would just add, to be clear, in an asset sale, you can and often do, the buyers take assignment of the Medicare provider numbers and agreement because they want to keep it. Yeah. Not always, but often.
Not always, but often. And again, that's one of the things you want to negotiate very carefully in your purchase agreement. So this is, again, is why your purchase agreement needs to be looked at very, very carefully. In an equity sale, the purchaser is buying the seller's equity interest. And so basically you acquire the whole business lock, stock, and barrel, all the assets, all the streams of income, all the liabilities, and so on. And so on paper, the agency is owned by the same owner, the same entity after closing, and so you'll have the same tax ID number. There's a third kind of a transaction, which is where 2 companies come together. They form an entirely new entity, or one company merges into the other. This is a little bit more complex. We don't see it quite as often, but those are the 3 major kinds of transactions. Next slide, please. So we have some unique issues in a healthcare transaction. Go back one, please. Yeah. So in an asset sale, again, most home health and hospice agencies don't have a lot of what are called hard assets. Hard assets are things like cars, computers. Typically, you don't own a building. It's really that you've been providing services, and therefore most of the value is in goodwill. So here you can take assignment of Medicare billing numbers, but they won't take on other liabilities. So for example, let's say you owe a lot of taxes, or there is a debt. The purchaser won't want to take that on. Where you have non-healthcare debts, a lot of non-healthcare debts, or the buyer doesn't want the Medicare or Medicaid numbers, that's where you'll often see an asset sale without taking on the Medicare, Medicaid numbers. Or if in, for example, private equity, if you have a very highly risk-averse buyer, you will see asset sales. And what they'll just do is they'll just fold those assets often into an existing business. If you have an LLC, you'll have a membership interest sale, or if it's a C corporation or an S corp, you'll have stock sale. So here again, the owner doesn't change, only the shareholders or the members of the owner change. And this is a situation where, again, you will accept typically assignment of the provider agreements. And again, you're going to get all of the other liabilities, be they contract, tax, lease, so on, and so on. So you want to make sure you understand what the implications are of an asset sale versus a stock sale. And a merger.
Hey, Heidi, real quick.
Yeah.
So in a stock sale, they're often preferred by buyers who want a sort of a seamless transition and want access to the sellers, all of the good things that come along with the target of the acquisition, the contract, payer agreements, whatever those might be. They want them to stay in place, and they want a fairly clean and quick kind of sale. And stock and membership interests are very, very common. The kicker in those is expect there to be a ton of due diligence on liabilities, because most buyers in a stock membership interest sale are going to want all those liabilities satisfied before closing, unless they expressly agree to take them on. Obviously, Medicare, Medicaid liability, you can never entirely get rid of if you take assignment of the Medicare agreement. But generally, these are what we call debt-free transactions. And so they're going to want you to have satisfied any existing liabilities either before you close or out of the purchase fund.
Yep, good point. And in a merger transaction, what your liability is going to look like is again going to depend on how you structure it and how you negotiate it. Next slide, please. So when you have the transaction, one of the main things is going to be structuring the purchase price. Now, buyers, of course, want 100% of the, sellers want 100% of the purchase price at closing, whereas buyers do not want to do that because, again, you're concerned about potential liabilities down the line that are unclear or undiscovered. So we typically see holdbacks ranging from 10 to 25% of the purchase price, and sometimes even higher, again, sort of based on the risks and the due diligence results. I've seen holdback periods varying from 6 to 36 months. I've seen step agreements where, part is released at 6 months, another tranche is released at a year, another tranche is released at 2 years, that kind of thing. You should probably consider a formal escrow account or agreement, and this is to protect the seller, and it also ensures that the funds are there when the holdback period is done and when the buyer has to pay out that escrow. Sometimes you have sellers who are willing to do owner financing, and they permit the buyer to put down a down payment with, again, payments over time. Those are going to be subject to a secured promissory note where the business secures the payment. So there's lots of different ways to structure the purchase price. These are some of the most common ones. We also see purchase price adjustments at closing, and these are very common. Again, things like paying off the debts of the seller, sometimes paying the transaction costs of the seller. Sometimes there is a payment from the seller to the buyer to make sure that there is sufficient working capital that they can just step in and take over this. You will also see purchase price adjustments sometimes if anticipated revenue doesn't meet a certain level, or if you've lost patients during the pendency of the transaction. That's another kind of adjustment that we can see. Next slide, please. So part of the documentation in your purchase agreement is going to be what we attorneys called reps and warranties, or representations and warranties. And these are essentially statements that you make and you swear that they, or legally confirm that they are true, or those conditions are true. You may have disclosure schedules that identify specific exceptions or facts. Often there is a whole laundry list and a section in the purchase agreement for your reps and warranties. Reps and warranties are very important because a materially inaccurate rep or warranty is actually grounds for the buyer to sue or seek indemnification. So a common example of a rep and warranty, for example, would be that the agency has all the licensing that it needs and that the licenses are in good standing. So obviously, if that's not the case, if let's say there is a license that is on probation or is under some kind of scrutiny, that is going to affect the value of the business. And that's why the reps and warranties are so important. So again, common reps and warranties include a statement that the financial reports are true, accurate, and complete, that there is no litigation or audits pending, and that the conduct of the business has complied with all applicable law. Very common reps and warranties. Next slide, please. So we also have reps and warranties that are unique to a healthcare transaction. And again, you won't necessarily see these in, a general business sale, but because of the nature of healthcare, very important here. As I mentioned, one of the reps and warranties is that the seller has all of the licenses, certifications, and contracts necessary to operate, and that they're current and in good standing. If you're worried about Medicare or Medicaid, you want to make sure that the seller is enrolled in Medicare or Medicaid, and that these enrollments are, again, active and not under scrutiny. You want to have a rep and warranty that the owners are not subject to any disciplinary or corrective actions or appeals. Again, particularly important where you have licensed personnel. A very important rep and warranty that people don't seem to think about a lot is that the seller has been conducting exclusion screening, has records of it, and has no employees, contractors, vendors, owners, officers, etc., who are excluded. This is actually overlooked a lot, and it's a very problematic thing. The government is proactively checking to make sure that there are no excluded individuals, and they are proactively reaching out to companies when they believe somebody who was excluded is actually working in a healthcare field. And I've actually dealt with multiple circumstances where the government has proactively found people when the entities have not been doing their sanction screening themselves. Another rep and warranty is that there are no claims, enforcement, or other actions, administrative proceedings, audits, or investigations pending. Again, you want to make sure if you're a buyer that that is very, very tightly written. And finally, in home health agency deals, the seller has to make a rep and warranty addressing the 36-month rule. As you all know, there is a rule that there cannot be changes of ownership in the last 36 months. It triggers certain problems if you've had a change of ownership. So you will want to know if there has been a change in majority ownership in the last 30 months. And you want to ask that during the due diligence phase and you want to make that a rep and warranty in your purchase agreement.
And Heidi, I just would add, that's probably one of the first things I go through with either buyers or sellers when, even before the letter of intent stage, have you asked this question? Do you know the answer? Because everybody's wasting their time. If we get deeply into a deal and discover that there has been a change in majority ownership sometime within the last 36 months, and then we've got to go and strategize what to do about it. And sometimes there is no solution other than wait. And that's never a comfortable position for anybody to be in when you're already, invested a lot of resources in a deal.
Good point. Good point. Next slide, please. So you're also going to want to look at indemnifications. So you there? You there?
I can hear you.
Oh, okay, I just had a call beep in and I was afraid it had disconnected me. Okay.
You're loud and clear.
Good, awesome. So during indemnification, this is again another focus. Again, this is going to protect the buyer where the seller agrees to compensate and hold harmless the buyer for any problems that may arise in the business or the operations of the business as a result of the seller's actions prior to closing or as a result of breaches of their reps and warranties. And again, I typically, and I know Jennifer does this as well, we always talk to our clients about whether you want to escrow a portion of the purchase price to cover any of those unknown liabilities for a defined time frame. It's something that I actually recommend to my clients simply because in this day and age, there is just so much out there that you can't always know about it. Next slide, please. You also want to have qualifications and exceptions. These are anything that limits a party's liability. That may be a cap on the indemnification or a minimum amount of indemnification or a disclaimer or a revision of certain reps and warranties. And we have a materiality provision here. You don't want to have any kind of a disclaimer or an exception for piddly little stuff. So many times you'll want to have that it is a material change in the business. Again, things to think about as you negotiate the deal. Typically, we also have time limits on indemnifications, and these are often pegged to the statutes of limitations for different healthcare laws. And again, your qualifications and exceptions are usually very, very negotiable because they are so fact specific and really relate to the transaction in front of you. Next slide. So when you have a purchase agreement, there's two ways of doing this. You can either sign the purchase agreement and then have closing sometime later, or you can do signing the purchase agreement and going to closing on the same day. Both methods work for home health. We often and usually see the purchase agreement being signed and then closing occurring sometime later. And this is the case because you're going to need some usually regulatory consents involved. In Texas, as you all know, a true change of ownership or an asset sale does require a minimum of 30 days advance notice to HHS and a new license application procedure. And if you have a waiver contract with Medicaid, then you've got a 60-day minimum advance notice period. So in those cases, you definitely want to sign your purchase agreement, do what you need to do, and then actually go to closing after the relevant time period. If you do that, or even if you sign your purchase agreement and close on the same day, there is a conditions to closing provision, and this is a key section. And these are key material elements of closure. So failing to meet these is grounds not to close the transaction. And as examples, we have the buyer can't qualify for a license, or you don't get key consents, or regulatory approvals, or financing falls through if you have any kind of financing. Next slide, please. All right, so that brings us then to closing. At closing, you all review all of the documents. You agree to any necessary additions or revisions. You may sign ancillary documents, like if you're transitioning a lease or entering into a lease, employment contracts, that kind of thing. So at closing, what happens is you officially transfer the ownership of the assets or the equity, and you also transfer the purchase funds to the seller and or deposit funds into the escrow agreement. Next slide, please. It's very important to understand that the relationship between parties rarely ends after closing. Again, many buyers want a transition period where the seller stays on and insists in retaining employees and patients and transitioning the business. The goal of the seller during this period is to minimize any exposure to liability. But by the same token, the buyer is now running the business with all of its challenges. And this, again, is a prime time when a seller, when a buyer realizes that a seller should have disclosed something, and the buyer finds it, and the buyer says, "Okay, now I've got to seek some kind of a legal remedy." Also, some transactions, as we said, have deferred payments. There's a whole bunch of different kinds. There's an earn-out, there's the escrow type of thing. And so you're going to rely on each other to comply with all of these deferred payment obligations and reporting. Next slide, please. There are some other things that go on. So many deals have restrictive covenants. These are, for example, non-competes and non-solicitation provisions. And other covenants may be to the benefit of, the other party. Covenants concerning employers, the employees, terminations, pay, severance. We very commonly see these the subject of disputes, particularly non-competes. Non-compete covenants and non-solicitations must be reviewed by an attorney. There are very specific requirements in Texas for what is an enforceable non-compete. And we always look at three things: time limits, the scope of geography, how far the non-compete applies, and the practice area or the scope of the services to be included. Next slide, please. Again, you may have post-closing purchase price adjustments based on valuations or sharing of accounts receivable. And this is something you really should put in your purchase agreement as well, defining how AR is going to be split. And this needs to be very specific. You're going to have, in most cases, patients that are going to straddle the date of closing with their episodes. So you really want to make sure you understand it. And this is something you need to negotiate up front and nail down in your purchase agreement. Buyers often will want price adjustments as well, because again, sometimes you have such a long time between signing the purchase agreement and actually closing. What the buyers don't want to have happen is the seller basically stops operating the business and the business falls apart while you're waiting for close. So that's another way that the buyers can ensure that they're getting value for the money they're paying by including these purchase price adjustments. And finally, you've got to file your change of information or change of ownership applications. And these have to be done in a timely basis, and you want to make sure that you get those done pretty quickly. Next slide, please.
All right, Heidi, I was going to pick up from here, I think. So,
yep.
A couple of special issues for home health and hospice. Licensing requirements can drive a transaction timeline, as Heidi mentioned earlier. Asset sales, where you're going to have a new owner with a new EIN, absolutely 100% require a licensing application in Texas. Ideally, that's filed 30 days in advance. That's what the regulations require. You can fudge that a little bit if the circumstances permit it and pay a late fee. I highly discourage it. I 100% discourage doing an asset sale before the buyers deliver their license application. You can endanger the license and lose it if you, and really what happens in that scenario is A, you either endanger the license entirely, or B, you end up having to redo the entire deal structure and kind of unwind and redo things because whoever's helping you with your license application or HHS comes back and says, hey, we have a problem. So if you're doing an asset sale, timeline is very important. There are advanced filing requirements. Equity transactions where you're doing share or member interest purchases do not require advance notice on the licensing side, but they do have a very short post-closing timeline to update ownership information and any other changes associated with the business. They also, regardless of the type of deal, whether it's asset or equity, if the target agency has a contract, a waiver contract with the state, primary home care, family care, et cetera, you absolutely have to file, the buyer has to file a new application with, for a contract at least 60 days in advance. And I will tell you, having handled several of those over the last year, that 60 days in advance is probably not enough. I would seriously consider giving yourself 90 days. The people processing those applications has been extremely slow. And I've actually had to hold deals up because the state couldn't get their work done fast enough. Often buyers want to manage if there's going to be a long period between signing a purchase agreement and actually closing a business. Sometimes that's to address a 36-month rule problem where we need to wait to actually close the transaction. Sometimes it's just a matter of the seller is ready to walk out the door or needs some support in the interim period from a financing perspective. There are lots of reasons why a buyer might need to come in and provide interim management while you finish a deal. I've done lots of deals like that over the years, and it's important to build it into the overall deal and clearly understand what everyone's role is going to be during that management period before the sale actually happens. Needs a written agreement, and people need to understand how things are going to work while that's ongoing. Let's go to the next slide. Some other really special things, in any transaction, the buyer is going to want to see all of the seller's contracts. Those could be payer agreements, those could be vendor agreements, they could be medical director agreements, therapy agreements, anything and everything. The ones that tend to hold things up and make things more complicated are payer contracts and sometimes vendor contracts, and it really in leases, those, especially real estate leases, those tend to be the most problematic. The reason is that sometimes those contracts include provisions that say if there's a change in control, and that would happen in an equity deal, you've got to get our consent or we can terminate the contract. Likewise, if you're doing an asset deal, those contracts do not automatically necessarily assign to the buyer if the contract includes assignment language that requires the other party to the contract to consent to that assignment. That's very common in payer contracts. So if your agency has a contract with Humana or Anthem or Blue Cross, that contract probably says you can't assign this to a third party unless you get our consent. And in an asset deal, that's exactly what's going to happen. And so you have to get these advanced agreements from these payers or vendors or third parties in an asset deal to assignment of a contract. And that can take time, and you've got to build it into the overall structure of the deal. It's very important to early on talk about what staff will be retained. Asset deals, this becomes more of an issue than it does in equity deals. Understanding that any transaction is a very sensitive subject for the seller, especially. It's really important to control the flow of information about a potential transaction and to keep the circle of trust fairly tight for quite a while. Meaning the people that know about the transaction and know what's happening can be fairly limited, at least on the seller side, for almost right up to closing. The reason being, as you might imagine, once it gets out that a seller is looking at a transaction, staff get nervous, patients get nervous, and they start jumping ship. And so I always encourage conversation early on about how are we going to roll out knowledge about the transaction? How are we going to transition staff or retain staff and retain patients and manage that proactively? Don't forget about accreditation. If you are an accredited agency, CHAP, Joint Commission, et cetera, there will be notices that have to be given. Generally, those accreditations can continue regardless of the form of transaction, but you've got to go through their process to notify them about whatever has happened. Buyers should always look at sellers' compliance plans, policies, procedures, and any audits. That's always a big issue in a healthcare transaction, specifically in home health and hospice.
And don't forget the HIPAA stuff. and don't forget HIPAA.
Heidi is my resident HIPAA expert, so I'm glad she brought that up. Anytime I have a HIPAA issue, she's the person I call. HIPAA is important, and we always tell clients when we're talking about HIPAA that it's not a matter of if there's ever going to be a HIPAA breach or if there's been a HIPAA breach. It's just a matter of when. It's going to happen. Something's going to happen eventually, and so it's important to explore whether there's been an issue, and if so, if there's been an investigation and if it's completed.
And you've probably already had a breach and you just don't know it.
Probably, yeah, unfortunately. Buyers are always going to need to consider cost-saving strategies that can be realized in a transaction. Generally speaking, a buyer, when they acquire another business, is looking how they're going to fold them into their existing organization and what kind of administrative systems are in place that you can leverage to run that target agency more efficiently or realize more value from it. And oftentimes you've got outreach and marketing plans that are in place or can be augmented or supplemented by that business that you're bringing in. So it's important for buyers to look at the big picture, and sometimes a good deal is not really that great of a deal. Sometimes it's a better deal than you expected, but there are so many factors that go into that analysis. Let's go to the next page. This is my last slide, I promise. Just reminding everybody, transactions are complex. They often take quite a bit of time, but it is absolutely, I love doing transactional work, and I love representing sellers because, generally speaking, it's a major life event for owners, and whether it's being done because you're sailing off into the sunset and want to retire and spend time with your family, or you're buying business and you're growing a business, and we're playing a role in helping you do that. I find it tremendously rewarding, and I think my buyers and sellers would feel the same way. It's important in any transactional process to maintain the integrity of the business that's being bought or sold. It's really important that it is supported and that it is able to operate in its customary manner while negotiations are ongoing. It's really important to think through the structure of the deal so that you don't have fraud and abuse issues on down the road. You've got to engage experienced professionals that can advise you, whether you're a buyer or a seller, in things like transaction structure, evaluation, et cetera. This is the time to engage your lawyers and appraisers and accountants to help you get the best possible deal terms on the table for both buyer and seller, and to make sure that that what you've bargained for is going to be what you get, and that there aren't going to be regulatory issues that undermine that value. And be aware of long-term risk allocation. Heidi mentioned reps and warranties and indemnification, and anybody who's been in the transactional field long enough has had a deal where something's come up after closing, like an audit, and you've either ended up counseling your buyer about indemnification or counseling a seller who's provided that indemnification and is now having to go in and defend an audit for a business they don't own anymore. I've been on both sides of that, and it happens. It isn't common, I would say, but it happens, and it's important that you've planned that out in advance and captured whatever that plan is going to be in your transactional document. All right, that's my piece. Heidi, you have anything you want to add?
What Jennifer said.
Again, I'm happy to answer questions. Heidi's happy to answer questions if anybody has any right now. Otherwise, that's our contact information, and you are welcome to reach out to us offline. I know the slides will be sent out to everybody later this afternoon. And so if you have questions that come to mind after the fact, feel free to reach out.
Kip, do we happen to have any? Yeah, do we have any questions yet?
I have taken a look and we are yet to receive any questions.
Okay. Awesome. Well, everybody have a great day, and we appreciate you listening.
Thanks all. Bye-bye.